Martin van BEYNEN Last updated 1707, October 6, 2017. Singaporean investors in a Queenstown development have won in the Supreme Court. A Supreme Court decision has ordered the return of $10 million worth of deposits paid by mainly Singaporean investors in a failed Queenstown hotel and apartment development. The court ruled in favor of the investors on an appeal by vendors Kawarau Village Holdings Limited and Melview Kawarau Falls Station Investments Limited in receivership. The litigation was connected to a development by Auckland-based Nigel McKenna and his entities of a three-stage complex on the edge of Lake Wakatipu. It was to include 3 5-star hotels, a 4-star plus hotel, a serviced apartment complex and conference center. The McKenna entities went into receivership in 2009 and 2010 due to the global financial crisis and could not go on to start stage 2 and 3. Read more. Queenstown GFC fallout, investors hit for $36 million. Property Solutions Singapore defends marketing. Auckland Kawarau Falls buyers suing developers for $20 million despite the curtailed development. Investors were asked in 2012 to settle on units purchased in Stage 1 and refused. The vendor then cancelled the sale agreements and claimed $10 million of deposits plus interest. The Supreme Court, in a judgment released on Friday, said the purchasers were entitled to refuse to settle as the contract called for the completion of the entire complex. The vendor was therefore not entitled to cancel contracts and by doing so had repudiated the contracts, absolving the purchasers of the need to settle. Their deposits of about $10 million plus interest held by a stakeholder should therefore be returned, it said. The appeal was therefore dismissed and $35,000 in costs awarded against the appellants. Justices Young and Oregon dissented, saying that although the vendors were obliged to finish the development, it was not an essential term of the contract, which meant the purchasers should have settled. Stuff.